using history or not to decide cases. What we're going to do now is build a decision-making toolbox for analyzing the First Amendment. And one of the most important things to understand the Supreme Court and how it's evolved since 1986 is to understand the increasing use of history by certain justices in deciding cases. As I mentioned in the past, judges can either be historians or a political philosopher combined with a social scientist. And I want to tell you something about Antonin Scalia to understand his concept of using history called originalism. Now, to understand what Antonin Scalia, who was on the court from 1986 to 2016, what he was trying to accomplish, you need to understand a little bit of the history of how judges were historians on the Supreme Court. John Marshall, who was the third Chief Justice of the Supreme Court, he talked about the history of the Constitution, but he talked about it as a person who was the head of the Virginia Constitution Ratification Convention, and he was talking about what the Constitution meant then. When we talk about the modern era, I think really the credit for exploring the nature of history on the Supreme Court should go to Hugo Black, who was on the court from about 1938 to 1971. Hugo Black was a New Deal liberal appointed by Franklin D. Roosevelt and a former senator from Alabama. And what he did was he said his theory was to look at how the framers wrote the Constitution and how they wrote the Bill of Rights and the other amendments. What did those words mean then? He was a literalist. He did strict interpretation of the Constitution. He talked about the First Amendment being absolutely protective of those rights. Congress shall make no law abridging freedom of speech. No law means no, capital N, capital O, multiple exclamation points law. His argument was if the framers wanted to protect those rights, they should be read absolutely, they should be read literally. That's not what Scalia is doing. Scalia comes out of a different tradition. In the mid to late 1980s, the Attorney General for Ronald Reagan, Edwin Meese, came up with a theory called original intent. He argued, along with a Court of Appeals judge named Robert Bork, that what judges should do is they should look for what did those words in the Constitution or the amendments mean to the authors of those words. You need to get inside their heads, and you need to understand what their intent was. It was a way, they said, of taking the judge back in time to when those words were written and limiting them just to what the judges said. What Meese was arguing was you need to use history as a limitation, and in his thinking, it was a limitation on progressive activist judges. It was not necessarily a limitation on conservative activist judges. Well, Robert Bork was very much in the running for a seat on the Supreme Court. And sitting on the same Court of Appeals as Robert Bork was Antonin Scalia, who realized that Bork was better known and had been mentioned for the Supreme Court several times already. And he was looking for a way to come up with a new concept that might make him more appealing to Ronald Reagan, when Ronald Reagan was trying to fill the seat vacated by William Rehnquist, who had just been elevated to replace outgoing Chief Justice Warren Burger. So what Scalia came up with was a theory called original public meaning. And he argued before a group of very prominent administration lawyers that what you should be doing is not just looking at the author of those clauses in the Constitution or the amendments. You should be looking at what the general public understood those words to mean. Don't look at the author, look at the audience. And his argument was, we are looking for the original public meaning of the Constitution. What did the people at the time of the Constitution, 1787 to 1788, what did they think those words meant? What did the people at the time of the Bill of Rights, 1788 to 1791, what did they know those words to mean? Well, the place he said to look was in the ratifying conventions for the states for the Constitution and the Bill of Rights. Now, the problem here is any good historian would tell you when you look at those ratifying conventions, there are going to be people who are pro national government, and there are going to be people who are pro state government. There are going to be people who are pro governmental regulation of rights. There are going to be people who are pro non regulation of those rights themselves. Historians will tell you you can't know what people thought those words would mean. And so Scalia said, well, I'll tell you what I'll do. I'll look at the various dictionaries. I'll look at the various newspapers. I will look at the various letters. I will look at all of the discussion of these issues, and I alone will tell you what this history means. He was basically making judges into historians. And he was arguing that the best way to limit a judge's power is to go to those founding era documents and determine what the people understood those words to mean. When you say the words cruel and unusual punishment from the Eighth Amendment, Scalia said what you should do is you should look not just at the dictionary definition of cruel, unusual, and punishment, but you should look at what the people were doing. And he said, I have no problem with the death penalty because one of the penalties for stealing a horse, for a felony at that time, was you would be hung. And so it meant that the framers understood that they were still protecting death penalty. And he would argue throughout his time on the court that the real meaning of cruel and unusual punishment was to ban torture. You can't continually try to hang somebody if it just doesn't seem to work because the rope has been breaking. Scalia had a theory that he could mold to reach the result that he wanted. He wanted to do a conservative analysis of the court. But every now and again, he would face a case, say somebody who was burning a flag because they didn't like the Reagan administration, in which he could say, I'm not crazy about what this protester did, but my originalism tells me I still must support what that protester is saying. Now, sitting on the court with him is another type of originalist. It's Clarence Thomas. And Clarence Thomas's version is, I'm not going to look at the Constitution. I'm not going to look at the Bill of Rights. What I'm going to do is I'm going to look at the Declaration of Independence. And in the Declaration of Independence, there are 3 inalienable rights: life, liberty, and the pursuit of happiness. And those 3 inalienable rights, they are what I'm going to protect. And so he will take these cases and he will look at what did these inalienable rights mean then? What should they mean now? Thomas is sort of a moving target, though. Over time, he's doing something a little more than that. He starts to look at newspapers from the time, and he starts to look at the context of the meaning of the words and the actions that happen in the original period. More so than Scalia, he's looking at the newspapers to get the result that he wants. And I will argue later in this lesson, he has a very different approach from that now. But originalism has different versions of it. Now, I don't want to leave this discussion with you thinking that the only originalists are conservatives. They are not. Stephen Breyer, David Souter, John Paul Stevens, all of them moderate to more progressive judges, 2 of them appointed by Republican presidents. They have used this sort of historical analysis to reach results in different cases. And one of the best originalists on the court now in 2024 is the newest justice, Ketanji Brown Jackson, who is teaching the other justices, you know what? I can find all kinds of progressive, expansive rights evidence in that early history. You don't have a monopoly on history because you are a conservative justice trying to make a decision. And so she is trying to battle with them over the meanings of history. It's a very instructive intellectual debate. Well, opposing this idea of originalism are those who are looking at the living, evolving constitutional meaning of those words. They are known as living, evolving constitutionalists. And the way they would do this is they would look at when was the last major precedent in this area, who was on the court in that year, what did they say the Constitution meant? They would basically look at the voting membership of the Supreme Court in the last major case in the area that you are analyzing, and they would say that this is a continuation of the Constitutional Convention. They have now changed the meaning of that constitutional provision, and so I'm going to go back to that period and not to the founding era. I'll give you a specific example. In 1939, the Supreme Court ruled that the Second Amendment, the right to keep and bear arms, actually only referred to military weapons. And so the Supreme Court said that a man named Miller, who was a bank robber, could not take his sawed-off shotgun and go across state lines to rob banks with it. It was a violation of a federal law from the middle 1930s, which banned shotguns and what were called Tommy guns or machine guns from being carried around or owned. Now, a living, evolving constitutionalist like John Paul Stevens would say, that's what the Second Amendment means now. And the living, evolving constitutionalist like John Paul Stevens would say, well, William McReynolds looked at the Second Amendment and understood that there were two parts of the Second Amendment. There was the individual right to keep and bear arms, and there was the collective right of society, a well-regulated militia being necessary for the security of a free state. They were saying, because we need to have the Minutemen or a posse in Northfield, Minnesota, stopping the James Gang from coming into town and robbing the bank, because society needs a militia to defend them, then the individual should have an individual right, but only to have a gun that will work for military purposes. The whole thing gets fouled up because if you know history at all, you know that the Marines in the Bay of Tripoli fighting those pirates had what was called a blunderbuss, a giant, almost like a pirate's curved gun that had two barrels and was basically a sawed-off shotgun. And you'll know, if you're a fan of the movie 1917 or World War I, that one of the things that people did in the various trenches is they sawed off their shotguns so they could protect themselves in those trenches. They wouldn't hit the trench with a larger shotgun. The military did use a sawed-off shotgun, but never mind that McReynolds didn't get the history right. The argument is the living, evolving constitutionalist would say the Second Amendment means a limited right for owning guns, limited by what the military uses. In 2008, Antonin Scalia, the great originalist, did not follow his technique. He did not talk about the right to keep and bear arms. He invented a new right, IRLPRAC. I'm not talking about the Second Amendment right to keep and bear arms. I'm talking about Scalia's Second Amendment right to defend yourselves in home and hearth. It's a very limited right. And what Scalia did is he said, I'm going to get that result from looking at all these dictionaries and looking at what the Second Amendment meant. Not at the time of the writing of the Second Amendment. I'm going to look now at the time of the 14th Amendment Due Process Clause in 1868. More about that later. And so he's saying, I'm not going to follow the precedent. I'm not a living, evolving constitutionalist. I am an originalist. If you look at this battle between the use of history or the non-use of history, you understand what the court was like from 1986 probably up to about 2020. And you can see those battles between Scalia and Stevens, Scalia and Souter, Scalia and Breyer. And they're high-level intellectual battles. But one of the additional things that Scalia did is he said, in addition to originalism, I use textualism. I want to know specifically what each word means in that law or that constitutional provision. I do not want to look at the intent of the writers of the law or the Constitution, because I don't believe that congressional intent best tells you what the law was designed to do. And so he taught people how to use dictionaries and how to get the results that you need to understand what the law means by piecing together all of the meanings of all of the words in the law. This combination of textualism and originalism allowed Scalia to get where he wanted to go. One final word here. One of the most instructive things about analyzing this debate is to see the cases in which Scalia does not use originalism. He could, but he doesn't, because his originalism will get him where he doesn't want to go. Another Fourth Amendment case, Michigan versus Hudson, is instructive. This dealt with the police who knew they were chasing a fellow who allegedly was dealing drugs and using drugs. They have a warrant, they go to his door, they knock on the door, and they hear somebody racing around in the apartment. And they immediately realize he's probably grabbing the drugs and flushing. And so they kick in the door within 3 to 4 seconds. They go and they grab him, they prevent him from disposing of the drugs, and they arrest him. This case goes to the Supreme Court. You would think that Scalia, the great originalist, would say, that's exactly what we're talking about. The framers of the Constitution and the Fourth Amendment understood this is what the British troops did. And we want to keep them from knocking and kicking in doors. They need to take their time, knock on the door, and announce, we're here, we want to search your apartment. It's an easy call for an originalist, but that's not where Scalia wanted to go. So instead, he never talks about originalism. Instead, he talks about the professionalism of the police and why they needed to make these moves, and there's an emergency, there's a drug problem. But wait, if you read that case and read the dissent by Stephen Breyer, he's the originalist, doing exactly what I'm talking about. There's a Third Amendment that says you can't quarter troops, or don't have to quarter troops. And there's a Fourth Amendment that says they can't kick down the door. He basically is writing Scalia's originalist opinion. So this is a tool. This is a mere suggestion, as Geoffrey Rush would say in the Pirates of the Caribbean. You don't always have to use it.